School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 5 Intellectual Property and Data Management. Unit 11 Data Protection and Privacy. Part 2.
Information Technology Act and the right to privacy. Though not a legislation drafted primarily with the aim of privacy protection in the digital context, some of the provisions of the Information Technology or IT Act 2000 have implications for privacy protection. For example, Section 43A of the IT Act deals with compensation for failure to protect data and clarifies that an enterprise handling any sensitive personal data, that is SPD or information, can be held liable for causing any wrongful gain or wrongful loss by being negligent in establishing reasonable security practices and procedures in handling SPD or information. While this statute does not define sensitive personal data, the term data has been given a broad definition in this statute. It is defined as a representation of information, knowledge, facts, concepts, or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed, or has been processed in a computer system or computer network and may be in any form including computer printouts, magnetic or optical storage media, punched cards or punched tapes, or stored internally in the memory of the computer. Rule 3 of the IT Rules 2011 has, however, provided a definition for sensitive personal data or information, and as per the rule, sensitive personal data or information of a person means such personal information which consists of information relating to password, financial information such as bank account or credit card or debit card or other payment instrument details, physical, physiological and mental health condition, sexual orientation, medical records and history, biometric information, any detail relating to the mentioned clauses as provided to body corporate for providing service, and any of the information received under all the mentioned clauses by body corporate for processing, stored, or processed under lawful contract or otherwise. However, Rule 3 also clarifies that any information which is available in the public domain or furnished under any law will not fall within the purview of the provision. Section 66E of the IT Act deals with voyeurism and provides that any person who willfully captures, publishes, or disseminates the image of a private part of any individual without consent, leading to violation of their privacy, shall be liable to punishment with imprisonment extending up to 3 years or fined for an amount not more than 2 lakh rupees or with both. Section 72 of the IT Act provides penalty for breach of confidentiality and privacy by statutory authorities empowered under the IT Act to secure access to private information in the form of record, book, etc., and for its consequent disclosure to a third person without the consent of the person concerned. As per the provision, violators may face imprisonment up to 2 years or fine up to 1 lakh rupees or both imprisonment and fine. Section 72 Clause A provides punishment for disclosure of information in breach of lawful contract by any person, including an intermediary who has gotten access to personal information about a person and without his consent discloses it to another with an intent to cause wrongful loss or wrongful gain. The prescribed punishment is imprisonment up to 3 years or fine up to 5 lakh rupees or both. The transfer of personal data is regulated by the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. Rule 4 directs body corporate collecting, receiving or storing information to provide a privacy policy for dealing with the personal information and to guarantee that the same can be viewed by the providers of such information. This rule further directs the body corporate or any person on its behalf to publish on the website the statements, type, the purpose of collection and the reasonable security practices employed by the former. Rule 5 provides that the collection of information by a body corporate shall be done only after obtaining consent in writing from the provider of the information. Rule 6 provides that disclosure of SPD or information by the body corporate can only be done post obtaining the consent of the provider of the information where it is required for complying with any legal obligation. Rule 7 lays down that the transfer of SPD or information to any other body corporate located in India or any other country shall only be done with the consent of the provider after guaranteeing that the level of data protection offered there is commensurate with these rules. As we have learned that some of these provisions do deal with protection of privacy rights. However, it is now indisputable that the effectiveness and adequacy of these provisions have been in dealing with the privacy-related challenges in the digital context are far from ideal. Some provisions of the IT Act such as Sections 69, 69A and 66A, which was struck down, may have also resulted in chilling effects on free speech by empowering authorities to issue blocking orders to network providers based on interceptions. Also, the provisions were increasingly proving inadequate to deal with the increasing amount of data breaches. Right to privacy and the need for specific data protection laws. Protection of privacy in the current digital context requires framing of specific policies and procedures that can minimize the intrusion of both private persons, including companies, and the state into the privacy of an individual by generating, collecting, storing, using, collating, or deriving data about the individuals. For the purpose of discussions in this unit, data can be categorized into two, that is, personal data and non-personal data. Personal data includes characteristics or traits which may be used to identify an individual, while non-personal data, on the other hand, encompasses aggregated data which may not serve in identifying an individual. If we observe the data protection approaches in the United States, China, and Europe, one can understand them taking diverging approaches to data protection based on their respective socio-political requirements and outlooks. For example, the United States pursues a somewhat laissez-faire approach and is seen not so keen to have a specific comprehensive legislative framework for data protection, with the emphasis traditionally being on protection of business interests and deregulation. The US uses an amalgamation of constitutional provisions and general laws for establishing a framework for privacy protection. China does not have a unified data protection legislation like that of the European Union, and takes reference from numerous sector-specific legislations to establish a data protection regime. Provisions relating to protection of personal data also appear in the PRC Cybersecurity Law of 2017, despite it being touted as a national security legislation. In EU, the Data Protection Directive was adopted by the European Commission in 1995, which laid out the framework for data protection regulation. The directive provided a framework for processing of personal data, including rules in relation to collection and destruction of data. In 2018, EU took the approach of drafting a comprehensive privacy legislation with great emphasis on the protection of user rights through extensive discussions among the member states to enact the General Data Protection Regulation, that is GDPR. Under this legislation, the state is entrusted with strengthening the individual's privacy in the digital era and for laying down privacy rules as regards companies and public bodies. Data Protection Framework in India. It may be recalled from the discussions in the earlier part of this unit in the Puttaswamy decision, the Supreme Court had categorically mentioned the need for an appropriate data protection framework in India. In July 2017, the Indian government decided to form a committee to study various dimensions of data protection and suggest inputs for an appropriate legislative framework in the area. Under the chairmanship of retired Justice B.N. Sri Krishna, the committee gave a comprehensive report delineating the rationale for a robust legal framework for data protection, and the committee also provided a draft Personal Data Protection Bill. Key aspects of the retired Justice Sri Krishna Committee report. The Sri Krishna Committee report defined personal information to include any data which may be used to identify an individual either directly or indirectly. Personal data was defined on the basis of their identifiability with the law, including processing by private and public entities. Sensitive personal data was to include financial information, passwords, health information, sexual orientation, religious and political inclination, with the Data Protection Authority, that is DPA, empowered to include further categories. The committee also sought to differentiate personal data protection from the protection of sensitive personal data. The committee noted that the relationship between the individual and any service provider must be observed to be a fiduciary relationship, that is, a relationship based on fundamental exception of trust between the two parties, and that there should be a fine balancing of interest between the two. This conception of the relationship also led to the committee adopting the terminology of data principal and data fiduciary as opposed to the terminology used in other data protection legislations in the world, that is, as that of data subject and data controller. The establishment of a regulatory framework stems from the fact that there is a need for protecting the rights of an individual referred to as the data principal, who is the focal actor in a digital ecosystem with reference to their personal data. The basis of a fiduciary relationship is the execution by an individual regarding fair use of her or his data for legitimate purposes. Hence, there arises a duty on the part of the entities collecting the data for dealing with the data responsibly. Such entities are referred to as data fiduciaries. The draft bill suggested regulation of personal data by providing rules for protection of autonomy of individuals, with reference to their data, along with laying down norms for processing, collection, and storage of such data by the data processing entities. The report provided a number of recommendations, starting with the need for setting up an independent regulatory authority, the Data Protection Authority or DPA, which would be entrusted with the enforcement of the law. The DPA, as per the suggestions of the report, shall be empowered to classify certain data fiduciaries as significant data fiduciaries depending on their power to cause greater harm in pursuance of their data processing techniques. The data fiduciaries have been mandated to undertake obligations including consenting to data audits, data protection impact assessments, along with getting registered with the DPA. The DPA was also bestowed with enforcement mechanisms empowering them to issue directions, calling for information, publishing guidance and codes of practice, providing injunctive measures while carrying out inquiry, issuing warnings, cease and desist orders, and suspension of business of entities violating the law. Establishment of an appellate tribunal for adjudicating and disposing of appeals against any order of the DPA also found place in the suggestions in the committee report. As per the suggestions in the report, consent was considered to be mandatory for processing of personal data. The report suggests adoption of a modified consent framework where data fiduciaries shall be held liable for any harm befalling on the data principal. Consent needs to be free, specific, clear, informed, and capable of being withdrawn in order to be valid. The report also suggests that processing of personal data by the fiduciaries must be fair and reasonable. Data fiduciaries shall be bound to follow the principles of purpose limitation, that is, data fiduciary shall use the personal data collected only for the purpose for which the data principal expects it to be used. Also, it should follow the principles of transparency, providing notice, that is, right at the time of collection of personal data, and storage limitation, that is, storage of data only for the time period required to fulfill the purpose for which it was collected. Also, processing cannot be performed in the absence of an express consent by the data principal unless the purpose for the same has been communicated at the time of collection. The committee also recommended the inclusion of data principal rights such as right to confirmation or data principal's right to inquire about the processing of his or her personal data, access, that is, right of the data principal to obtain access to her or his personal data in the control of the data fiduciary, correction, right to data portability, that is, right to receive and transfer the data stored with the data fiduciary, right to object to processing, right to object to direct marketing, and the right to be forgotten, that is, right of the data principals to delink, amend, or correct the information that may be disclosed on the internet by the data fiduciary. The draft bill also proposed a three-tier system based on the data localization requirements. Data has been categorized as personal data, sensitive personal data, and critical personal data. While personal data may be allowed to be transferred freely, sensitive personal data may be transferred only after obtaining explicit consent by the data principal and subject to government approval. Critical personal data may not be transferred except on very limited grounds. Cross-border transfer of data apart from critical personal data not subject to cross-border transfer, which may only be processed in India, may only be done with the help of a model contract containing clauses holding the transferor liable for any harm caused to the data principal due to violation of the law. The committee also provided grounds where processing may be done on non-consensual grounds which include welfare functions of the state, compliance with any law or order of a court or tribunal, or any other reasonable purpose. Further, the processing of personal data or sensitive personal data may be exempted in certain situations, including in the interest of security of state, for personal or domestic purposes, disclosure of personal data for the purpose of legal proceedings, for acts in contravention of any law in force, personal purposes, and manual processing by small entities. The draft bill laid down that the Data Protection Authority or DPA may levy penalties on the data fiduciaries for failure to comply with data processing obligations, the directions issued by the DPA, or cross-border data storage and transfer requirements. The report along with the draft bill was submitted to the Ministry of Electronics and Information Technology on July 27, 2018. The Personal Data Protection Bill 2019. The Personal Data Protection Bill, that is PDP Bill, was introduced in the Lok Sabha on 11th December 2019 and it was subsequently forwarded to a joint parliamentary committee, that is JPC. While the bill has retained many elements of the draft bill provided by the Sri Krishna Committee, it has also made some radical changes. This section will highlight the major differences between the draft bill provided by the Sri Krishna Committee and the bill which was introduced in the Lok Sabha. The definition of personal data, which was defined in a way so as to include characteristics, traits, or attributes of identity used to identify an individual, was expanded to also include any inference being drawn from such data for profiling purposes. The definition of sensitive personal data, which included passwords as per the bill proposed by the Sri Krishna Committee, was amended to remove passwords from under this category. The power to categorize personal data as sensitive personal data, which was conferred upon the Data Protection Authority or DPA under the draft PDP bill, has been granted to the central government in consonance with DPA under the 2019 bill. The Sri Krishna Committee bill had no reference to social media intermediaries. However, the 2019 PDP bill not only provided a definition but further necessitated the social media intermediaries classified as significant data fiduciaries to provide a voluntary user verification mechanism for all users. The Sri Krishna Committee bill had further exempted the state from abiding by the requirements of the bill while processing personal data in the interest of national security as long as it was permissible under law and performed in a fair and responsible manner. The 2019 bill, on the other hand, grants the government the power to exempt any of its agencies from the provisions of this act in certain cases, like security of state, sovereignty and integrity of India, public order, etc., thus enhancing the powers of the government. The 2019 PDP bill incorporates data subject rights such as the right to erasure, granting the right to the data principal to request data fiduciaries for erasing any personal data that may have been stored by the latter once the purpose has been fulfilled. The Sri Krishna Committee bill also required one serving copy of all personal data to be stored in India every time transfer of personal data took place outside the country. This mandatory storage requirement for all personal data has been removed in the 2019 PDP bill, necessitating only mirror copies of sensitive personal data and critical personal data to be stored in the country. The conditions for transfer of sensitive personal data also includes receiving express consent by the individual whose data is being transferred outside the country. The composition of the Data Protection Authority or DPA was also subjected to certain modifications in the 2019 PDP bill. Under the Sri Krishna Committee bill, the selection committee was empowered to give recommendations to the central government for the appointment of members of the Data Protection Authority comprised of number 1. Chief Justice of India or a judge of Supreme Court as the chairperson, number 2. Cabinet Secretary, and number 3. An expert in the field of data protection, information technology and related subjects. However, the 2019 bill does away with the requirement of a judicial member from the selection committee. The selection committee, as per the 2019 bill, consists of number 1. Cabinet Secretary as the chairperson, number 2. Secretary Department of Legal Affairs, and number 3. Secretary Ministry of Electronics and Information Technology. While the Sri Krishna Committee bill neither defined non-personal data nor envisaged application of non-personal data by the government for making policies for digital economy or security, the 2019 PDP bill, in addition to defining the term, also empowers the government to direct data fiduciaries to provide any non-personal data and anonymized personal data for better targeting of provision of services. Additionally, the 2019 PDP bill has brought forth the concept of privacy by design policy, whereby every data fiduciary has to prepare a privacy by design policy and get it approved by the Data Protection Authority. Now let's summarize the unit. As the Supreme Court has clarified through the landmark decision in Puttaswamy case, the right to privacy is a fundamental right in India. Like many other fundamental rights, while a privacy right cannot be considered as an absolute right, it is very important that effective and adequate measures are put in place to protect privacy rights, particularly in the current digital context, wherein the threat of infringement by actors including the state is non-trivial and profound. A robust data protection regime that can assure the best possible protection of privacy rights for individuals is the need of the time. The key principles laid down by the Supreme Court in the Puttaswamy decision has been a good starting point for designing a robust data protection regime for India. The report of the Joint Parliamentary Committee on Personal Data Protection Bill has been tabled before both the houses of the Parliament on December 16, 2021. With the bill titled as the Data Protection Bill 2021, it looks to regulate not just personal data as was envisaged by the Sri Krishna Committee, but also include within its scope non-personal data until a framework to differentiate between personal and non-personal data is set up by the government.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.